Hi, I'm John Strohmeyer with Strohmeyer Law, where we help our clients leave no unfinished business. While I am a lawyer, I'm not your lawyer, so don't take the advice of some talking head on the internet. Talk to your own advisor about your specific circumstances. Also, don't forget to like, comment, and subscribe. Today, you're going to see my discussion with Bill Gross on Estate Planning Weekly, where we addressed one of the most dangerous trends in estate planning right now, the so-called no, you can't do that trusts and scams surrounding them. Now, in other videos, I've talked about some of the scams that are out there and trusts that really don't address and don't provide the benefits that people say they have. In this conversation, we're going to talk about the IRS's 2023 memorandum on non-grantor, irrevocable, complex, discretionary spendthrift trusts. These are legitimate tools when actually used correctly, but promoters often misrepresent them as a secret way to avoid income tax altogether. The real truth is that these trusts are taxed under the Internal Revenue Code just like individuals. The question is who pays the tax and when, not whether the tax can be avoided entirely. We'll also talk about the differences between tools like revocable living trusts, which are often essential in states like California to avoid probate, versus aggressive schemes that misuse the provisions of the Internal Revenue Code. A living trust is not a scam when used correctly. It's like a hammer or a saw, safe and effective in the right hands, but dangerous if misused. Finally, we'll discuss how estate planning is not only about the tax rules, it's also about considering people, personalities, and responsibilities. Picking the wrong person to be trustee or leaving assets to an unprepared heir can create just as much damage as a poorly drafted plan. Let's get to that interview. It's good and sounds good for you?
Let's do this. Hey, welcome to Estate Planning Weekly. I'm Bill Gross. No, you can't do that trust scam. What is that? Well, oftentimes I do podcasts with attorneys. They can't give legal advice because they haven't signed you on as an attorney. They can give you general business advice, but they can't tell you to avoid a pattern of scams. And I was on another one of my podcasts, Probate Weekly, with John Strohmeyer, attorney out of Texas, and he was talking about the no, you can't do that trust. And I thought it was fascinating that we should invite him here for our Estate Planning Weekly. John, thank you for joining us and picking such an exciting topic.
Bill, it's great to be back. Thanks for having me. That's, lawyers get blamed as doctor knows, or, how can we say no? And sometimes our job is really to tell you, no, you can't do that, and no, you shouldn't.
And I think in general, if something sounds too good to be true, except for if an attorney tells you to sign here, all of a sudden becomes too good to be true, that's a problem. And that's true with the with the scam associated with the IRS memo 2023. Talk a little bit about that particular memo, what it does do, and then what it doesn't do.
Sure. So there are all sorts of trusts out there. As an estate planning attorney, I use lots of different trusts, and there are all sorts of good reasons to use them. What happens, though, is there are people online who are overselling what you can do with a trust. And unfortunately, it can get clients, or people who follow along with them into a lot of hot water with the IRS. So here it is, 2025. Back in 2023, the IRS relieved Technical Advice Memorandum 2023-006. And if you want, you can Google that and read along with us if you'd like. But what it does is it addresses one particular type of trust that's out there that, again, doesn't do what the promoters purport it to do. So these are, they can be called multiple different things, but non-grantor, irrevocable, complex, discretionary spendthrift trust. Now, these are real things. Non-grantor and complex mean the same thing for federal tax purposes. It means that that trust is treated as a separate taxpayer. It's going to report and pay tax on its own. Irrevocable means kind of what it says in that the trust agreement, once it's signed, you really can't change it. Discretionary refers to the powers of the trustee to make discretionary distributions, and then spendthrift, meaning it has spendthrift protections for the beneficiaries from creditors' claims. All of these make sense. All of these work as a real type of trust. The problem you get into is people will then go and cherry pick provisions of the Internal Revenue Code and say, well, we can put this trust together, and once we've done that, presto chango, it's a secret of the rich that the IRS doesn't want you to know about, because you're not going to have to pay income tax on. Some get more aggressive and say anything inside the trust. Others say, well, no, it's only passive income. The short version is, your basic rule on income taxation is if you're a U.S. citizen or a tax resident, you're inside the realm of the IRS, you will be paying annual income tax with kind of very minimal exceptions. Certainly one of those exceptions is not the non-grantor, irrevocable, complex discretionary spendthrift trust.
So when we spoke last time on Probate Weekly, you mentioned the scam trust. So I did a Google search on the term scam trust. And the first answer that I got was wrong, which was the living trust scam attempts you to purchase a living trust. Well, hold on. There are people who need a living trust. In fact, I founded this podcast to encourage more of my customers to have a living trust. So the fact that you buy a living trust in and of itself isn't a scam. Now, are the people who don't need one? Maybe, if you're in California, you own property. If you're in California and you have a family, I would say it's good business, not as legal advice. You should have one. But generally speaking, if you own a property, estate plan's critical. Living trust is probably going to be part of that, right?
Right, and there's nothing wrong with the living trust.
Nothing.
It's like a hammer or a saw. You're probably, if you use it as intended, it's all fine and nobody's going to be upset. It's when you go beyond what you're supposed to do with a hammer or saw and start hurting other people. And this is where the metaphor starts to fall apart. But really, there are things you can do that are perfectly within bounds. In California, where you are, you basically need to have a revocable living trust to avoid probate and all the costs associated with that.
Right.
Here in Texas, it's a little more optional. You don't have to have one. And so we talk to our clients about what is appropriate for them and their circumstances. But there's nothing necessarily or nothing inherently scammy about those revocable management trusts. The problems come in when you get a little aggressive on the tax plan.
Well, let me just stop right there. So in general, to say this, a living trust is a scam is obviously bad advice just to begin with. It's a tool. And I think use your analogy, it'd be like me buying a hammer and a saw. I'm never going to use a hammer and saw. I just have it for my son-in-law comes over and needs them to improve our house, kind of like a living trust. I'm not going to need it, but when my son-in-law and daughter, after I'm gone, it's a tool that they'll use. Then I used ChatGPT and said, what are the top 10 trust-related scams? I got answers. Living trust mills. That's really just a company that does nothing but basic living trusts, and they do them less expensively. And to call them a mill is pejorative. Now, are the people who do a lot of volume and do a poor job? Sure. Is a bad trust better than none? Maybe John and I disagree. My business sense is 9% of the time, any trust is better than no trust because you can work on it faster. At least the property maybe is already deeded in the trust. As a real estate agent, I like it a lot better.
Right. And that's the thing. It's just kind of, there are things to do, and yes, there are those will mills or trust mills where they're just kind of churning out documents. They're not doing anything to make sure that the plan fits together. Again, your people are selling things and usually playing fast and loose with how they work and what they can accomplish.
Now, just like, tools that can be used to hurt yourself or do good, like, for example, the Medicaid trust scam, there are ways to use trusts to help somebody qualify for Medicaid who otherwise wouldn't. There's a scam that they'll sell you the trust, and it won't really qualify you because you can't one day sign the trust and the next day qualify. There's a process that you have to go through, right. and it gets oversold, and then people have a tax bill due or have the benefits that they get charged to the state, and they're surprised. That is a scam. It's the same tool. It's either used properly or improperly, but it's a very powerful tool if you use it right. Please use it right. But when you Google non-grantor revocable complex discretionary spendthrift trust, that's mostly a scam.
Right. And that's the thing. It's just it gets into being creative and, again, misreading provisions of the Internal Revenue Code to try and achieve tax results that just flat aren't there.
So when we talk about trusts, it's interesting. It's an interesting word in estate planning. We talk about estate planning and one of the tools being a trust. In a world increasingly affected by artificial intelligence and technology, where increasingly the documents created by these computer systems are getting better and better, maybe not as good as attorneys, but that gap is narrowing every minute, every nanosecond as the systems improve. The one thing that the computer can't do really is create the human-to-human relationship trust. So, for example, could you have a customer this trust might be the right tool for them? I imagine 1 in 1,000, right, or 1 in 10,000 that'd be the appropriate tool for them.
Well, I mean, here's the thing. What I'm trying to separate is not the non-grantor complex irrevocable spendthrift trust. That's a tool we use for just about every client. You know, that this type of trust, well, if you have a trust that's set up to be created and funded on somebody's death, generally that's what you're going to get. If it's some sort of testamentary or resulting trust, a marital trust could potentially be one of these. A family trust or a bypass trust will be one of these. A trust for the benefit of a child that lasts for the rest of their life. It's going to be one of these trusts. The problem is the people who say, well, there's a magic provision in the code where you're going to convert this passive income, or you're going to declare that the income there is not income, but it's trust corpus. And as a result, you no longer have to pay income tax on it. And that's where the people get into problems.
Right. So when I've been involved with talking to estate planners on large estates, complicated estates, it seems that there are things that are magical, but the magical things almost always center on who is taxed or when you're taxed, not whether or not you're taxed.
Right.
There's step-ups based on who owns the property or doesn't own the property. There's distributions and then who owns it and who pays the taxes. There's date of death versus whenever you distribute or taxes owed on assets before. But although somebody's paying tax, the question is who and when, not poof, it just disappears, correct?
Right. I mean, the descriptions I've heard over the years for things like this are, well, no, it's just not taxed, or we're achieving tax deferral, or it's only taxed when the beneficiaries get it, or even it never gets taxed again. And again, this is too good to be true. Trusts are, and the Internal Revenue Code will tell you the exact same thing. Trusts are taxed like individuals. Go look at Internal Revenue Code Section 641. Trusts kind of pay tax on the same basis, which means calendar year, as money comes in cash basis, they're going to have to recognize that income and pay tax on it. And there's a wrinkle because trusts are different. This is where we get to something called distributable net income. That's Internal Revenue Code Section 643. And this is where those promoters go. And they see, well, there's this calculation for the income and that gets allocated to the beneficiary and not the trustee, meaning there's still only one layer of tax. It's either, our default is the income comes into the trust and the trustee is going to pay the income tax due. But if certain income is distributed out to a beneficiary, well, then the beneficiary is going to pay that tax. And there are times to do this where, you look at the trust income tax rates, you look at the beneficiary's income tax rates, and you may want it may be advantageous to have the trustee distribute income so the beneficiary pays it, allows more to be, more assets to potentially grow inside the trust. Again, there's a lot of reasons to do it. But what doesn't happen is you're not deferring income tax. What you're doing is saying, well, look, we're going to tax it to a beneficiary because the beneficiary's income tax rate may be lower than the trust's income tax rate. As a starting point, well, individuals, you don't hit the top income tax bracket until you've had hundreds, 4 to 6, depending on, what year and what your status is, but hundreds of thousands of dollars of income versus a trust where they're going to hit the top income tax bracket at about $14,000 to $15,000 worth of income. And so, you're just going to kind of blast through and be at the top bracket for a trust very quickly. And there are things to think about. And there are planning opportunities for that, especially given our current estate and gift tax climate. But what we don't have is an option to defer.
Right. So there was a lot of talk about potentially the exclusion amount reverting down to the pre-2017 number. With the passage of the One Big Beautiful Bill, the current exemption is continued, I think, for at least 10 years. And so there's a lot of consternation and concern about what that might have looked like that doesn't apply. But I feel like sometimes people say, oh, good, well, now I have doing estate planning. No, that's not what it means at all. Maybe tax rates aren't going to go up, and maybe those tax rates aren't going to be raised or retroactive or whatever. But still, you can almost make as much profit with good planning as you can on making income. So what do you see as one or two of the most common, people come to you with their estate and don't put it into a plan. What are one or two of the most common mistakes or opportunities that you see to help people when they come to you with a plan? Not a scam. We're not selling something that's not true, but what are within the tax laws, what are the opportunities and benefits that people can benefit from?
Right. And so one of the things that, and you mentioned it, it's people thinking, well, I don't have that much. I don't need an estate plan. Well, it doesn't matter what we call it. And look, I call it an estate plan because really the idea is we're mapping out what people should be doing. And whether we achieve that plan with a will or a trust or a singing bush that tells people what to do, just knowing what should happen to your stuff is part of it. And just kind of thinking through what should happen so that we can make sure things get to where you intend them. There's not a right or a wrong answer. There's, whatever your answer is for you, your stuff, and your family. So, kind of getting over well, no, you don't have 7 Porsches and manicured lawns. You still need some sort of plan. So that would be thing number 1.
Well, I try to tell people you have a plan. If you think you have a plan, you have a plan. It's called, in my case, the State of California plan. It looks like the Department of Motor Vehicles department. It's just worse than that. So that's your plan. You can have a better plan if you exercise it, but that's the default plan that the State of California has for you. And if you're okay with the State of California, and I'm going on about that, I have a whole podcast on the State of California. If you're okay with them deciding what to do with your legacy and your finances and who to put in control of that, by all means, let the state do it. They're glad to do it for you.
Right. And, again, just if you don't make a choice, well, here in Texas, the Texas legislature has a basic plan for you, and you get to go through that grinder, which is, it's not great. It's not what anybody would actively choose, and we try and avoid it as much as possible.
One of the reasons why I'm sure you try to avoid it, just like I see in California, is that once people get into that system, it amplifies any problems inside the family, any sibling rivalries, any lost cousins that come out of the woodwork and had animosity, stepkids, kids from prior marriages, half siblings. If there's any animosity, it's going to come out turbocharged in a battle over the estate. And so talk a little bit about how you can't completely avoid that with proper planning, but you can really limit that with proper planning. Talk a little bit about some of the strategies to help avoid those issues.
Right. And as part of getting that plan, we're sitting down and thinking through, well, who gets what, but also who's going to be involved. We need to be thinking through everything that goes into your plan. So it's not just what happens now, but where are people going to be? Potentially you'll be passing away, years from now, decades from now, but we've got no promise on that. We want to think about the people who are involved in your plan right now and would be affected by your plan. And that's the point. It's really, how do we make sure that we're accounting for not only the assets, but the personalities, not just the tax ramifications, but the real world ramifications of giving somebody all of this money. Will they be able to handle it? I don't know. That's my job, is to help you kind of figure that out.
Yeah. Because you don't think it through. You give somebody who's never had any real money that responsibility,
right.
Especially if you're wealthy or ultra wealthy, then that becomes a whole different issue, perhaps, if they're not raised to handle that, prepared to handle those responsibilities.
Exactly. And, just kind of thinking through, this is what we do for people, and this is how we make sure it helps them. We've got to think through what all of that looks like for them.
So it sounds being parental, but if you're kids, you're allowed to be parental to your own kids.
Right.
I'm involved in a state now where the decedent was a very savvy, very active, expert real estate investor in a very narrow niche in downtown Los Angeles, knew the ins and outs, knew everybody, did well with it, passed intestate, and so his only heir is his son, who's handed this portfolio. And really, he didn't live in the state. He never was involved with real estate. He can be a really, really smart guy. He is, actually, and married to a smart woman, but they have no ability to take over a portfolio of commercial property in downtown Los Angeles. A bunch of them were leased to cannabis companies. Some weren't licensed. It was a very, very unique portfolio where somebody needs help. Had there been a plan, in place. Perhaps the father would have given some advice. It turned out we were able to step in. Talk a little bit about some of the things you can do ahead of time to help a transfer of very complicated estate to decedents who maybe aren't as experienced with complicated matters.
Right. And this is where, again, you're thinking through the personality. Who is going to get stuff? Are they going to be able to manage this? I mean, the obvious answer that everybody thinks about is, well, my children are under 18 and we don't want them to have it too soon. The 3-year-old certainly can't manage that account. But, as a 3-year-old, or a parent of a 3-year-old, you probably have some ideas, but no real kind of grounded experience on 20 years from now, what are they going to be capable of managing? And as they grow, you'll learn more and kind of figure out more things. Do they have any situations? Do they have any conditions where they might be limited? I don't know, but that's kind of the poking and prodding to make sure we don't just give it to them outright if they're not going to be able to handle it. But then thinking through, all right, well, if for whatever reason, whether they're 18 and we don't want them touching it for 10 years, or they're 35 and, special needs, and they should never be able to manage it. Well, who should? Kind of thinking through who are the people who are going to be involved in your plan, who are going to help carry this out and make sure, whether it's 1 year, they're serving as executor, they're a long-term trustee, or they're just there to kind of pick somebody else, maybe kind of show up and watch over a trustee. You want to make sure that you've got the right people in place to assist with that plan.
Right. And I think we've all seen people who, blow a lot of money they're inherited. I think I've seen people who inherit money and they end up never really achieving much because they got a little too much. They didn't mismanage it, but they didn't.
Right.
It just killed their incentive to grow as people. And I feel like I'm surrounded with a bunch of those people who are, they're well-to-do and they live a decent life, but they seem to have not grown as a result of not having to work or build a business or grow the assets. And these are the people who take those assets, maybe modest, maybe significant, and grow them and make something really big of it. And that's obviously everybody's desire if you have assets to leave to your family, but nobody has a crystal ball, right?
Right. Exactly.
Yeah, and I think that's the challenge. Now, if you were to estimate, obviously you have to have the technical know-how as an attorney to know the laws set these things up, but you also have to have the soft skills of asking these questions, probably probing a bit. Probably people give you a superficial answer and you kind of read that and have to learn how to get a little past it. How would you assess yourself in your practice today? How much do you have to rely on your technical skills and how much of it's with the soft skills or the experience that gives you the intuitions to be successful on the emotional and communication part?
Oh, goodness. Man, those percentages. Obviously, it's a mix of both. Our initial client meetings, we're spending the first half hour or so, usually just talking with clients about who's involved, what are they looking for, what does a good plan look like for them? What's the Smith family home run, because we don't want to give them the Jones family plan or whoever it is. We talk to lots of families and they're all different, not only personalities, but the asset mixes, where they're going, where they've been. And again, ultimately, what does that home run look like for them?
And so what are common home runs that you see people say, that's what I want to have happen at the end of the day?
You think people do mention taxes, but one of the big ones really is they want to make it easy for everybody. They don't want to leave a mess behind.
Right.
And, not only nobody's ever asked to leave a mess behind. There's some that may be a little more casual about what they're doing, but usually it's some version of, clear map, clear plan, smooth transition, easy. These are kind of what you see a lot of from people of whatever it's leaving, whatever they're leaving it, whether it's $100,000 or $1 million or whatever. They want to make it easy on those that they care about.
Being a real estate agent, a very common experience is somebody put the time together to very neatly in an organized manner, create a beautiful plan in a beautiful book, in a beautiful binder. And I'll say to them, I notice your property is held in your names, Bob and Mary. Have you ever looked into estate plan? Oh, we have an estate plan. Oh, really? And they go get the book and they pull out, and it's beautiful. And they show it to me, and like the top page has something on there, usually the deed that's not signed. Maybe it's signed and not recorded. Maybe, but it's not recorded because I know through public records it's not. The whole binder might not even be recorded. So to me, one of the biggest, most common messes I'm dealing with right now on a big estate is they paid the fee, they did 90% of the work, they didn't do the last 10%. I know it's not often the attorney's fault because we all get busy, we all have how hard you push your customer. You don't want to offend them, but you don't want to be lazy, but you don't want to be overbearing. Talk a little bit about how do you find that balance? What should the customer expect from you, and that balance between being pushy enough to help them complete the job, but also being sensitive to understand that people are busy.
Yeah, what I envision myself as, and trying to explain to clients, it's not my plan, it's their plan. They're coming to us. We're here as guides. We want them pointing, this is what our mountaintop looks like. This is what the result looks like. What I'm not trying, look, there are certain recommendations I'm going to make. I recommend that you have, a will or a trust as something. We're not, not really going to have a bush that if they keep it alive for the next 20 years, it'll tell people what to do. Top men are working on it in my greenhouse in the back, but in reality, we're going to go with the things that we know work. And so it does come down to, kind of coaxing it out of people. And there are, kind of phrases and, trying to get the clients to talk, asking those open-ended questions. And, there are times where we'll kind of say, all right, let me read this back to you, or this is what I've heard. Does this sound like what you're looking for? It helps us kind of clarify and make sure that we've heard the right thing from them.
Yeah, and I think we might even, you talk about a talking bush. I keep, in my mind, switching that to ChatGPT, accessible through your Amazon, I don't want to say her name, or your phone secretary, that you can say, so-and-so, write me an estate plan. It's me, my wife, we have kids, we have this much assets. You probably could get a plan that way, but that's not going to finish the job, because you need somebody to make sure that plan lines up with what your goals are as you work through that.
Right, and that's the thing, is when we're talking about having that sort of plan, how do we get to that? Well, sure, you will have a plan, but ultimately, ChatGPT is giving you something that's based on, the words they've read before. Use it for things. It's helpful, but it's only looking at kind of what it knows. It doesn't take full context of everything. And you get what you pay for it when it comes to things like that. Are there things to be used? Yes, it does have its place, but trusting, look, there's not a chance I'm ever going to use it to say, hey, generate this document. Why? Because I'm going to have to go back and read that whole document start to finish versus, look, we use forms. The reason we use forms is so we don't have to start from scratch on all of these.
Right, you created your asset already in the work you've done before. It's interesting you say, I had an attorney ask me to put together a list of all the communication on a pending matter. And I have Google, so I have Gemini built into my email. And I asked it to make a list of all the emails, and my voicemail comes to my email. And it did a great job. It probably was about 50 emails. It missed 2, but 2 very important ones I knew were missing that I corrected. And I asked it to summarize it. It did a great job, but it left out 1 or 2 really important points on the matter where we have an argument with a tenant. It didn't even analyze who the owner of the property was. So it's one of those things where it was really great, and I ended up with a great product at the end. I had a 2-page with all this, everything footnoted. But if I didn't look at it, it would have been a mess and would have been ineffective. So I think we're moving quickly towards that, but I still think there'll be room for us to oversee all this process. Let's talk about the practice. Does your business, would you describe it mostly as B2C, as in consumers coming into your business directly, or you could consider more B2B, where other attorneys or other professionals refer customers to you already on a professional basis?
Yeah, this is where the business itself is B2C, where our clients are individuals. They're generally not entities or anything else like that. But the best marketing we do is B2B. We take care of our referral sources because, conceptually, we're doing, Joe, the estate planner, he'll send us a couple families over the course of a year and kind of rack up the financial planners, the CPAs, the other attorneys who don't do what we do and are happy to send that work to us. That's where we're looking to build that, knowing that if we take care of them, we look good, make our referral sources look good, then it's a lot easier to just keep those relationships around. Right. Do we get people kind of organically through me appearing on podcasts, me posting things on my YouTube channel, things like that? Sure. But most of our clients end up coming through our referral sources. And so we want to make sure that we take care of that.
One of the main reasons I launched this podcast was I feel like real estate agents should be a bigger part of that process, and I think that we talked about previously. We know every customer that we start listing a house for, we know if they have a plan or not because we look at the public records. Every buyer buying a property, we had a chance to ask the question. We should know the answer before we start, and the asset should match the name. And yet we don't. And so I've really tried to encourage real estate agents to find local attorneys to refer customers to ask those questions. But at the same time, the real estate agents need to meet the attorney to feel comfortable, as well as to learn the key questions to ask and the key things to ask. So if a local real estate agent in your area or anywhere in the state of Texas wanted to do business with you, what are some of the ways that they could get a chance to know you as well as kind of know your business so they would feel comfortable then engaging with their customers with the idea of bringing them to you if they need the services?
Yeah, and so, obviously I'm everywhere online. You can either find me at StrohmeyerLaw.com or, go find our YouTube channel. We put out videos usually once or so a week to make sure that we know, or that we're kind of getting this good information out there for people to help explain what's going on.
I saw that information. That's why I reached out to you on the other podcast, because I do know you do a really good job of educating customers. It's really important to me, and I think also educating real estate agents. So if we can learn as realtors and or attorneys who are not in the space, if we can learn how to be more effective in this field, helping our customers, creating value, that's really what builds our business. So, John, I know you do. I put up on the banner here your contact information, your phone number, your email, as well as a website. And then the website is Strohmeyer.com. And let me go back to the front page there. I love the apocalypse of the four horsemen of the estate planning apocalypse. I'll leave that to anybody here who's on the show to go to the website and click on that. But he lays out the four main traps I think that people get caught up in if they do proper planning. So whether you go to the website, StrohmeyerLaw.com, and there's a call us button, or down below the contact info. It'll be in the description as well. Reach out. John, thanks again for educating the marketplace, and thank you for taking time to educate my platform and the people I work with.
Bill, pleasure to be back. Thanks so much.
And for the rest of you, this was Estate Planning Weekly. We do this every week. We interview top estate planning attorneys from around the country, as well as professionals that service that business. I'm a real estate broker in Los Angeles, California. I'm Bill Gross at BillGrossProbate.com on social media. If you want to continue the conversation, we have a Facebook group, which is called the Estate Planning Podcast. Go in the group there, ask questions. If you're looking for referrals, introductions. And if you're on this call watching this, and if you either are an attorney that'd like to be interviewed or know somebody who should be, please feel free to reach out. If you like this, please like it, subscribe if you like it, ask me questions if I can help in any way. As always, make today your best day ever. Thanks so much.
Thanks for watching my conversation with Bill Gross on Estate Planning Weekly, where we unpack the truth about trust scams and the importance of solid planning. We highlighted how promoters misuse technical terms to sell false promises of tax-free income, and explain why trusts are still going to be subject to federal income tax under sections 641 and 643 of the Internal Revenue Code. Still, the emphasis is on having a trust as a powerful tool, but not some magic escape clause from tax obligations. Ultimately, you're going to want to make sure whatever you're setting up fits for you and your situation, and also fits within the bounds of the law. So thanks for watching. And remember, the best estate plan is one that actually works for your family when it matters.